Oh boy, day 10 of the Assange hearing. Do you remember what they've been telling us? What they were telling us from the very beginning? Oh no, we're not going after journalists. We're just going after Assange, and Assange isn't a journalist. Don't worry, we're not going to go after the New York Times or the Guardian. Free speech and free press, that's all safe. It's just Assange because Assange isn't a journalist. Well, guess what? Counsel for the U.S. government has actually come right out and said in the Assange hearing that all journalists are liable for prosecution under the Espionage Act, and as soon as they get this as a precedent, yeah, they've been lying to us this whole time, but we knew that. At least the smart ones of us did. I mean, well, what about the rest of the mainstream media? Come on, New York Times, do you not understand? Guardian, where are you? Washington Post, do you not see what's going on here? They're threatening you. They're threatening all of us. Also, they argued that the Pentagon Papers Supreme Court judgment, you know, the one that said they can't do this because free speech and First Amendment and all that, that only referred to pre-publication injunction. In other words, prior restraint, which it was talking about, but it also made the First Amendment argument on top of that. And it specifically did not preclude prosecution under the Espionage Act. So yeah, they're saying they can do this to any journalist they want, anytime they want. And Craig Murray writes, "It is hard for me to convey to a British audience what an assault this represents by the Trump administration on American self-image of their own political culture. The First Amendment is celebrated across the political divide, and the New York Times judgment is viewed as a pillar of freedom." I mean, I'd like to think that's still true. The First Amendment has really come under a lot of fire lately, especially from the left. So, I don't know. Are they just not wanting to stick their neck out on this one, lest they'd be seen as hypocrites, or I don't know, but I'd like to think that most people aren't like that. I'd like to think that most people are actually in favor of freedom of speech and realize how important it is. But he says so much that Hollywood's main superstars are still making blockbusters about it, in which the heroes are the journalists rather than the actual whistleblower, Dan Ellsberg, whom I am proud to know. The U.S. government is now saying, completely explicitly, in court, those reporters could and should have gone to jail, and that is how we will act in future. The Washington Post, the New York Times, and all the great liberal media of the USA are not in court to hear it and do not report it because of their active complicity in the othering of Julian Assange as something subhuman whose fate can be ignored. And he asks, are they really so stupid as to not understand that they are next? And he answers, yes. So the prosecution's line before has been basically the narrative we've been getting the whole time. Assange is not a journalist, and he did all sorts of things that newspaper journalists didn't do, which is actually what they do all the time. You know, Ellsberg did it, Woodward and Bernstein did it. And he says, experts in journalism also testified that Assange's relationship with Manning was not materially different from cultivation and encouragement by other journalists of official sources to leak. But that argument started going bad for the prosecution, and as we've seen, the approach has now changed, and on Tuesday, a radically more aggressive approach was adopted by the prosecution, asserting the right to prosecute all journalists and all media who publish classified information under the Espionage Act. The purpose of the earlier approach was plainly to reduce media support for Assange by differentiating him from other journalists. It had become obvious such an approach ran a real risk of failure if it could be proved that Assange is a journalist, which line was going well for the defense. So now we have any journalist can be prosecuted for publishing classified information as the U.S. government line. I strongly suspect that they have decided they do not have to mitigate against media reaction, as the media is paying no attention to this hearing anyway. Continued questioning of Eric Lewis by James Lewis, and they're talking about the European Court of Human Rights judgment in the case of Babar Ahmad. And Lewis is continuing his pop quiz of Eric, again to try and make it out like he's not a real expert. He says, what are the 5 limitations to their study which Waldman and Anderson mention? Eric, I don't have it in front of me. And then he says, why not? Why didn't you mention them? And Murray says the report in effect shows a much higher suicide rate post-incarceration among those who have been subject to solitary confinement from a very large sample of ex-prisoners. You're put in solitary confinement, you're much more likely to commit suicide after you're released. Because it's psychological torture. Every reasonable person knows it. So, Eric responds, I could have written hundreds of pages on recent social sciences developments on solitary confinement. This is just one such report. James, you were just fishing about for something, omitting details which counter your opinion. Well, you'd know all about that, wouldn't you? But anyway, Eric, there is a huge amount of data, including from the U.S. Bureau of Prisons. You just picked out one caveat of one report. James, please keep your answers concise. Oh, he doesn't like his BS being pointed out, does he? So, all these other things, why did you not mention it? Because it's not relevant, etc. He goes back to his old buddy Kronberg. He always falls back on Kronberg. And Kronberg said that as of 2 September, there was no COVID in the Alexandria Detention Center, which is where Assange will be kept pre-trial. Lewis countered, Eric Lewis, they're both named Lewis, I know, I'm using first names here, countered that levels of COVID in federal prisons in the USA are 18%. James, you stated in the press that the maximum sentence is 340 years, when now you state it's only 175 years. You miscalculated, didn't you? You took 20 per count as a base when it should have been 10. Eric, it was a mistake in an interview. You know, when you're being interviewed, there's a camera in your face. You can't look at notes like he is right now, so sometimes you say things wrong. So James comes back with, you don't really believe in 175 years maximum sentence, do you? It's just a soundbite. Eric started to answer, and James cut him off. Fitzgerald rose and objected that the witness must be allowed to answer. Bereitzer agreed. Yeah, I think Bereitzer's probably having enough of James Lewis at this point. So, Eric, the U.S. government has called this one of the biggest cases in history. Espionage convictions frequently attract long sentences. Pompeo has categorized WikiLeaks as a hostile intelligence agency. The government asked for 60 years for Chelsea Manning. I consider the charges in relation to the official sentencing guidelines. And then James goes back on Kronborg like it's the frickin' Bible or whatever. So, anyway, a little later, James, you suggest that the First Amendment precludes this prosecution. Eric, yes, there has never been a prosecution of a publisher under the Espionage Act for publication of classified information. James, are you familiar with the Rosen case of 2006? This was precisely the same charge as Assange now faces of the Espionage Act, conspiracy to transmit classified information to those not entitled to receive it. Have you read the case? Eric, not in a long while, because ultimately it was not proceeded with. So then James reads through these lengthy extracts, and Murray says that he's just writing down the gist, not the transcript, but James says, in the Rosen case, it is made plain that the receiver, not just the discloser, is liable to protection under the Espionage Act. The judge noted that although the Espionage Act of 1917 had been criticized for vagueness, Congress had never felt the need to clarify it. It noted the Fourth Circuit had rejected a First Amendment defense in the case of Morrison. Eric, Morrison was different. He was a leaker, not a publisher. James, the Rosen judgment also goes on to state that vagueness does not come into play where there is clear evidence of intent. And I've said this before, but it bears repeating. Anytime there's vagueness under the law, the benefit of that vagueness always goes towards the defendant, not the prosecution. Anyway, Eric says, when you consider the 100-year-old Espionage Act and that there has never been a prosecution of a publisher, then intent... James, interrupting again. I want to move on from intent to the First Amendment. Yeah, because you were losing that line of questioning, weren't you? But anyway, he says, at times, the government's interest in national security must override the First Amendment. Eric says, in times of imminent danger and relating to immediate and direct damage to the interests of the United States, it's a very high bar. And James Lewis comes back with the old canard, the right to free speech is not absolute. Eric, of course, the arguments are well rehearsed. Movement of troopships in time of war, for example, cases of grave and immediate danger. In the Pentagon Papers, Ellsberg was, like Assange, accused of putting named U.S. agents at risk. The bar for overriding the First Amendment is set very high. And then Lewis reads from something which might be the Rosen judgment, but Murray isn't sure, and says the journalist can be prosecuted. Is that what he says? And Eric says, yes, but he's wrong. I like Eric Lewis. I'm liking this guy. James, do you accept that the Pentagon Papers judgment is the most relevant one? Eric, yes, but there are others. James, a close reading of the Pentagon Papers judgment shows that the New York Times might have been successfully prosecuted. 3 of the Supreme Court judges specifically stated that an Espionage Act prosecution could be pursued for publication. Eric, they recognized the possibility of a prosecution. They did not say that it would succeed. James, so your analysis there cannot be a prosecution of a publisher on First Amendment grounds is incorrect. Yeah. Eric gave a lengthy answer to this, but the sound on the video link went out. The lawyers carried on, Murray says, so perhaps they could hear, but I know Julian could not because I saw him trying to communicate this to his lawyers through the bulletproof glass screen in front of him. He had difficulty doing this as he was behind them and they had their backs to him and eyes fixed on the video screen. Anyway, when the audio is back on, Eric says, there's been an unbroken line of the practice of non-prosecution of publishers for publishing national defense information. Every single day, there are defense, foreign affairs, and national security leaks to the press. The press are never prosecuted for publishing them. James, the U.S. Supreme Court has never held that a journalist cannot be prosecuted for publishing national defense information. Eric, the Supreme Court has never been faced with that exact question because a case has never been brought. But there are closely related cases which indicate the answer. James, do you accept a government insider who leaks classification may be prosecuted? Eric, yes. James, do you accept that a journalist may not aid such a person to break the law? Eric, no. It is normal journalistic practice to cultivate an official source and encourage them to leak. Seymour Hersh would have to be prosecuted under such an idea. And then we go into other things like access to the White House, which I don't see how that's relevant or anything like that. And they go into Dempsey, and then Lewis wants to go back to the testimony of Professor Feldstein the previous week. Do you agree with his statement that while the Obama administration did not take the decision to prosecute, he did not take the decision not to prosecute? That's not what he said. Go back and watch the video again. But do you agree, Eric? No, I believe that is predicated on a fundamental misunderstanding of how the Justice Department works, as we mentioned at the time. So, a little later, James goes back to Kronberg. Do you agree with Gordon Kronberg that prosecuting decisions are taken in line with federal guidelines that preclude political prosecution? Eric, no, not under William Barr. The system is now top-down political prosecution. James, so you claim the guidelines are not followed? Eric, I do. So do the 2,600 former federal prosecutors who called for Barr's resignation and the 1,000 former prosecutors who protested the Roger Stone commutation. Or Judge Gleason in his reports on political prosecution decisions. James, do you accuse Gordon Kronberg of bad faith? Eric, I don't know him, but I do know there is disclosure of heavy political pressure in this case. And then there's some discussion of how Trump changed his opinion on WikiLeaks, which, how that's relevant, I don't know. Edward Fitzgerald comes back for re-examination. And so Lewis explains that William Barr had made explicit that prosecution was subject to political direction. Barr had set this out in a memo that stated directly that prosecutors were merely the hand of the presidency. This was not theory. This was how the Justice Department was now run. Many federal prosecutors had resigned. Many had refused to touch the Assange prosecution. And then we go back to James Lewis trying to attack Eric Lewis's qualifications because he's not a penologist, but either is Kronberg. Does Mr. Kronberg have academic qualifications in penology as required by James Lewis? Eric replied he believed not, and certainly had no doubt he himself had greatly more practical experience of prison conditions than Mr. Kronberg. Mr. Kronberg's exposition of official policy was doubtless correct, but it bore no relation to the actual conditions in jails. On solitary confinement, Fitzgerald mentions the UN's Mandela rules, basically saying that 22 hours or more in a cell a day and no significant human contact constitutes solitary confinement. And Lewis replied that the SAM regime would definitely break the Mandela rules. So, that's the end of the redirect. Now we're on to Thomas Durkin. Fitzgerald asks him about the problems of cases working with classified materials. Durkin says, the biggest problem, you can't discuss classified disclosure material with your client. You can only look at the material on a special computer in a secure location and prepare your material there. Assange will not know what his lawyers have learned, nor will they be able to ask him what the material relates to or signifies. This is an incredibly difficult hardship in taking instructions and preparing a defense. Fitzgerald asked Durkin if there's a real chance that Assange will receive an effective rest-of-life jail sentence. Durkin replied, it's a very real possibility. He then asked about the plea bargaining system, and this is something I think that warrants a lot more discussion. Durkin replied that an early guilty plea reduces the sentencing score by 3 points. That could make several years' difference, but much more important is the freedom of the prosecution to reduce the counts charged in exchange for guilty plea. That could make a massive difference, potentially from 100 years plus to 10 years, for example. The system greatly reduced freedom of choice and was a massive disincentive to stand trial. People just could not take the risk. A large majority of Durkin's clients now took a plea deal. And I mean, we see that. The prosecution just throws, a billion charges at them and scares them with all of this potential jail time and says, but we'll let you plead to this charge and you're out in 30 days or whatever. I think that might be what they're doing with Rittenhouse, putting all of these completely bogus charges of homicide in a case it was clearly self-defense. And I think they might be able to say, we'll just let you off if you plead to a weapons charge. And I mean, especially think about how much this disproportionately hurts the poor. So you're a poor guy, you're just a working stiff, you got bills, you got rent to pay, you're hauled in on a bogus charge, it's going to be 30 days before you even get to your hearing. So what do? You can't stay in jail 30 days, you try to get bail and they set your bail at something ridiculous like $100,000, you can't afford that. And say, well, what am I going to do? If I can't work, I might lose my job. If nothing else, I'm not working this 30 days or however long it takes to straighten all this out. Then they cut my power off. The landlord evicts me. That's not just 30 days in jail. That's your life. And then the prosecution says, well, plead to this lesser charge, and then you're out the door. I mean, what would you do in that situation? I mean, it's ridiculous. It's psychotic. So much about our justice system has nothing to do with justice. Nothing to do with justice whatsoever. Fitzgerald then goes on about the grand jury, Kronborg's assertion that it's a powerful bulwark against political prosecution. Durkin replied, what we've been saying, this is simply untrue. A grand jury virtually never refused to authorize a prosecution. In the whole of the USA, there was generally about one refusal every 4 to 5 years. James Lewis then starts his cross. He asked about a fair trial. Durkin said that Julian Assange would not get a fair trial in the USA. Lewis suggested the requirement to see classified material was merely an inconvenience. Durkin said it was much more than that. You could not discuss material with your client, which materially limited your understanding of it. Lewis countered that U.S. Assistant Attorney Kronberg's affidavit stated that Assange would be able to see some classified material himself. A classified facility would be available for him to meet his attorneys. Durkin said he did not accept this description. He had never seen anything like it happen. But Lewis said, you could not know that. He had no idea what would be disclosed or what the defense would be, if any. If you remember, he pulled this same crap earlier. Durkin replied that much could be understood from the extensive indictment and from what happened in the Chelsea Manning case. Lewis repeated, Durkin did not know what would happen. Assange might plead guilty. Lewis suggested the plea bargaining system was in essence the same in England, where defendants could get 1/3 off sentence for a guilty plea. Durkin said plea bargaining in the U.S. went far beyond that. The government could put a big offer on the table in terms of reductions of charges and counts. Lewis then goes on to this change of policy between Obama and Trump. Durkin pointed out that the Washington Post of 25 November 2013 reported that the Obama administration would not prosecute, had quoted multiple former and then current Justice Department employees, and crucially, no denial or counter-briefing had ever been forthcoming. It had never been contradicted. Oh, remember what we were all saying? Remember what we were all saying about that? Oh, well, he has to stay in the Ecuadorian embassy because all the other stuff is a ruse. As soon as he sets foot outside of the embassy, the U.S. is going to try to grab him and prosecute him. Oh, no, you're just a conspiracy theorist. The U.S. isn't going to prosecute him. They're not going to do anything like that. They're not going to touch Assange. We all know that. Yeah, it was a lie. I mean, if Obama had still been in the White House when Assange managed to get out of the embassy, because that had more to do with the new Ecuadorian president than anything else, I think the same sort of thing would have happened. I think the only difference is that the Trump administration has just been a little more honest with how they go about doing things like this kind of prosecution. I think prosecutions have always been political. I think nothing's changed. We're just now seeing the sausage being made. And it ain't pretty. So thank you so much for listening. We'll do this again for day 11. Until then, please share these videos and please share Murray's blog posts and get this information out, because again, the news media isn't doing it, and you just heard how important this is. All of journalism, the entire First Amendment is being threatened here, and nobody's reporting it. Nobody's reporting it, so spread it around everywhere. And please hit like and subscribe, and hit the little bell too so you make sure you get notified of any future videos. Also, if you like what I'm doing, please go to donate.bogosity.tv and give what you can. We'll see you for the Day 11 coverage. Until then, stay strong and be free.